Good morning and welcome to Norcal APEX Accelerator's webinar, Mitigating Risk, Terminations for Convenience. My name is Amanda Anderson. I'm the Program Coordinator for Norcal APEX Accelerator, and today I'm joined by our fantastic procurement specialist, Joseph Moore. He also goes by Joe, and so Joe is a seasoned contracting professional who has provided professional services to many different firms, as well as being an actual contracting officer for the US Navy, large private industry firms, and in civil service. He has a ton of experience in government contracting, particularly on the federal side. He's a retired Navy supply officer and has an MBA from Webster University, as well as an MS in acquisition and contract management. He also holds a number of professional certifications related to contracting and government contracting assistance. But before I pass it over to him to begin our deep dive into FAR 49, I do want to let you know a little bit about Apex Accelerators and how NorCal Apex Accelerator can help you with government contracting. So the Apex Accelerator program is a federally mandated nationwide network of over 96 centers that are funded by federal, state, and local grants to provide businesses just like yours with education and training so that you can compete in the government market. And as you can see, we have about 7 or 8 apexes in California alone, as well as 96 centers nationwide, all founded in there to help you with government contracting at absolutely no cost to you. But what exactly does that help look like? How do we assist you in your business? Well, at NorCal Apex Accelerator, we're able to offer our services to the 15 Northern California counties you see on your screen. And we offer those services through 3 main pillars of resources. First, our one-on-one counseling, where once you are onboarded as a client with us, you'll be paired with one of our fantastic procurement specialists, just like Joe Moore, who can sit down with you one-on-one over Zoom. Or if you're in Humboldt County, we do have an in-person office on Cal Poly Humboldt campus where you can get one-on-one personalized counseling to help you with government contracting. They can help with anything from the initial market research to figure out what agencies you might want to target with your products or services, to helping you find relevant bids and solicitations that you want to put a bid in on. And your procurement specialist can even sit down with you after you've won your first bid and help you make sure that all the documentation is up to date and all of it's cross the T's, dot the I's, and good to submit. Contract compliance is a huge part of government contracting. Another fantastic service that you get when you sign up as a client is access to our custom bid matching software. Now, what this does is it allows you to sit down with your counselor and define specific criteria that you're looking in for a solicitation for it to be a good fit for your business. So maybe you can only perform services in a certain geographic location. Or perhaps you've been working on a very innovative product, and that product itself would be a key term that you're looking for in a good solicitation for you. Your procurement specialist can sit down and help you define these criteria. And then we put it into our software, which scrapes federal, state, and local procurement sites for opportunities that are relevant based on that criteria your procurement specialist helped you determine. And once it finds those relevant solicitations, it'll email all of them directly to you. And finally, our third pillar of resources is resources and trainings, which you're actually taking advantage of right now. We put on many trainings throughout the year, both in person and virtually, that are always free to attend and always welcome any business owners, whether you're in our service area or not. And we cover topics ranging from very introductory level items like capability statements and certifications to more advanced topics such as today's contract terminations at a federal level, or even how to read a DoD solicitation, which we'll be covering actually in a month. But in addition to the ongoing trainings we put out throughout the year, we maintain a robust website with links and resources for every level of contracting, federal, state, or local. And the best part about this pillar is it's absolutely accessible to anyone, regardless of if you're in our service area or not. You can access the links on our website and you can access prior event recordings on our website as well. So if you haven't had a chance to check out our website, I highly recommend you do so. A ton of resources to explore. But if you're looking for more hands-on guidance, you can go ahead and connect with your local APEX Accelerator, or if you're within our service area, please feel free to reach out to us and get onboarded as a client. We would love to help you find success in government contracting because that's what we're here to help with. And so with that, I do want to read a bit of training disclosure. The information provided herein is accurate to the best of the presenter's ability at the time of this presentation, and it is July 2025. Some or all of the provisions mentioned herein could or may be changed by the current administration, with or without prior notice. I also want to note, the FAR is contract terminology, and I just want to say that this training is not meant to be taken as legal advice. If you are facing a contract termination of any sort, this will give you a lot of good information, but it is not actionable. We highly recommend you seek legal counsel before you move on these items. And I know I keep saying and, but one final reminder about Q&A. We want to make sure that this event is as valuable for you as possible, and that means answering questions. So as a reminder, if you do have any questions about the content of the presentation, please enter those questions into the Q&A section and make sure that you are referencing not only the FAR subsection that we are discussing, but the slide as well, so that we can go back to that slide if we need clarification, if we want to discuss it a little bit further. So those two items, the FAR subsection and the slide page number, will be crucial to making sure that we can answer your questions fully, entirely, and accurately. So with that, I will go ahead and pass it off to Joe for the rest of this presentation. Looks like we can't quite hear you, Joe.
Stand by.
Can hear you now.
Yeah, okay. Can you hear me?
Yes.
Okay, I thought we were okay. You want to turn my video is on. I can't get it to come up.
Yeah, that should be fine.
Okay. Next slide, please. Well, a little bit of background here about FAR Part 49. FAR is the Federal Acquisition Regulation. That's what governs all federal government contracts for all agencies. It provides policies, guidelines, and procedures that are to be followed by contracting officers and the prime contract holder and subcontract to the prime. FAR 49 provides various termination procedures under different contract types, firm fixed price or cost type contracts, and construction contracts. This webinar is only going to focus on the requirements related to firm fixed price contracts, since this is the most common type of contract issued by the federal government. A firm fixed price contract, in case you're not aware of what it is, it's a contract where all the risk is with the contractor and the contractor has to provide a deliverable to the government. At the end of the presentation, you will see some information about some of the clauses located in Part 49. And at the bottom line, you have a link, and Amanda's going to put that in the chat section for the acquisition.gov regulation. This is where I'm pulling all my reference material from, and it's open for anybody to look and use. Next slide, please. Okay. The government has a unilateral right and the ability to terminate contracts in whole or part using the published guidelines to terminate for either termination for convenience or termination for default. These terminations involve specific clauses, procedures to ensure fairness and proper handling of government property and financial obligations. Termination for convenience, as indicated in subsection 100, is the one for termination for convenience. The government can terminate a contract when it's best interest to do so, even though the contractor hasn't defaulted. This typically involves a settlement process to compensate the contractor for work performed at a reasonable cost incurred. Termination for a default, on the other hand, is generally the exercise by the government for partial or full termination because the contractor's inability to perform or anticipated failure of that contract. A contractor does not want to receive a termination for default, and we'll get into that later on. Next slide, please. Okay, a couple terms I'm going to be using in here. We use a lot of acronyms in government contracting, and there's going to be some more during this presentation. But CO is a contracting officer. It's also referred to for DoD contracts as KO, contracting officer, because a CO in the military is a commanding officer. So CO is separate, is okay for other federal agencies other than DoD. DO is normally referred to as a KO. And in procurement contracting officer and termination contracting officer. Next slide, please. Now, how I'm envisioning making this presentation today. I'm going to provide you general information, a great deal of information in each area. Termination for convenience first, and then termination for default. It's very detailed. There's a lot of information in here, but what I tried to put in here for you was a complete FAR section that I started talking about. Some of these FAR sections in this presentation have 5 or 6 slides to them, where it just keeps on going and on going. We're not going to read every slide to you. Trust me, we've got 36 slides here. So I don't want to make the test too hard at the end. But I will give you specific elements that I feel are important to you as we go through this presentation. A few of the slides will be fully read because of that specific section. Understand, I'm not making you an expert on terminations, but I'm providing you basic information that you should be aware of as a government contract holder and a small business firm. Any specific questions you have about a real actual termination needs to be referred to an attorney. Next slide, please. Termination for convenience, T for C. Okay, we mentioned earlier the government has a right to terminate a contract for convenience or default, but the convenience is when the government's requirement has gone away. And the contracting officer shall effect a no-cost settlement instead of issuing of a termination when the following 3 elements apply. It is known that the contractor will accept a no-cost settlement. The no government property was furnished, and there are no outstanding payments or debts due to the government to allow a no-cost settlement. If you receive a termination for convenience, that does not affect your ability to receive and win other awards. Okay, next slide, please. Okay. When the price of an completely undeliverable contract is less than $5,000, it shall be allowed to continue to run to completion. Termination contracting officer, TCOs, is responsible for negotiating any settlement with the contractor. They are working for the contracting officer, but the contracting officer is still in the picture, but not the primary person, the point of contact here. The TCO has special rights given to them in that position title. Next slide, please. Okay. A notice of termination. The notice of termination may be expedited by any means electronic communications capable and providing confirmation of receipt. The notice will include the elements listed in items 1 through 5 below. And there is also an option in this clause for the use of telegrams for getting notices of termination to a contractor. Okay, next slide. Okay. The contracting officer may go back and amend a termination notice, provided these three subsections are met. Correct a non-substantiated mistake in the notice, add supplemental data or instructions, which would be additional delivery time possibly, rescind a notice if is determined that the item has been completed or shipped, but the contracting officer has not received that notice yet. The contracting officer also has the right to reinstate a terminated portion of a contract, either whole or in full. Whole or in part. Use it with, as long as those two sub-items are met. Next slide, please. Okay. Contracting officer will termination contracting officer will perform these functions, take direction actions required of the prime contractor, examine the settlement proposal of the prime and, when appropriate, any subcontractors, promptly negotiate settlement with the contractor and enter into a settlement agreement, and promptly settle the contractor's settlement by determination for an element that to promptly settle the contractor's settlement proposal by determining for the element that cannot be agreed on or is unable to be negotiated for settlement. So the TCO is your main point of contact. Okay, next slide, please. Okay, the TCO may request specific qualified personnel to assist in the termination of a contract. And this could include personnel from the Defense Contract Management Agency, which has functions of monitoring and receiving and issuing government furnished equipment, and in that area, providing reviews of progress. The other agency that could be called in is the Defense Contract Audit Agency, which does audits. Both of these agencies support all federal. Both of these DoD agencies will focus on other contracts other than DoD for assistance. But the termination contracting officer will go through this and bring in whatever necessary personnel that will be needed to terminate this contract and get a fair settlement for the contractor. Next slide, please. Okay. TCO may promptly hold a conference with the contractor to develop a definite program for effecting the settlement. Okay. The next slides, this slide and the next slide give 15 elements that the TCO could bring into that conference with the contractor. Number two, it's an important one, the extent of the termination, either is it full or partial, and obligations of the contract to terminate the subcontracts is another important issue. And then next slide, we'll let you look at these before we move on to the next slide, so you have a chance to see what's on the slide. But again, these are all direct statements from the FAR. Next slide, please. Okay. One here, number 12, is a requirement for interim financing. If the contract is partially terminated and there's work still ongoing, you as a contractor may need additional financing to be able to finish up what you have in the production line to where it can be delivered. So there may be some additional financing come into play. And item 14 is very critical. Making sure that the contractor and any subs have done everything they can do to minimize the impact on the employees affected by the termination. So these 15 issues are issues that can be discussed with the TCO as you company rolls into the process of having a contract terminated. Next slide, please. Okay. And then this one here is talking about release of excess funds. If there's excess funds on your contract, the TCO shall establish a fund required to settle the termination, and within 30 days after receipt of the termination notice, recommend the release of the excess funds. And what that means, if you have your contract's a 1-year contract, you're in your second month and you've been funded $1 million and you've only used $200,000, that excess funds, after what the TCO feels is going to be necessary to execute the termination of and the payoff of that contract, they will turn those funds back over to the contracting officer to be used under another contract. Again, TCO shall not recommend release of amounts under $100,000 and under $1,000 unless it's actually requested by the contracting officer. And the TCO will maintain continuous surveillance of the funding situation to make sure that you have adequate funds to finish your work on that contract in the agreement. And if necessary, if they have to bring some additional funds back into play, the TCO can work with the contracting officer to get that taken care of. Next slide, please. Okay, now, settlement of subcontract proposals. If you have subcontracts, you have to turn around and give a termination notice to them the same time you get yours. Termination for convenience clause provides that after receipt of termination notice, the prime contractor shall, unless otherwise directed by the TCO, terminate all subcontracts to the extent they are related to the performance of the prime work. Therefore, prime contractors should include a termination clause to their subcontracts for their own protection. And then there's a reference here in the FAR, Part 49, about some subcontracting termination clauses. The failure of the prime contractor to include an appropriate clause shall not affect the government's ability or right to require termination of the subcontract, and it will not increase the obligation of the government, the financial obligation of the government beyond what has been in effect if the subcontract has contained in an appropriate clause. This is worded differently. Okay, so you need to be aware of clauses in this FAR. We have 3 clauses. The first one is may, will, or shall. Shall is the top of the list. That's an absolute must. You may have some in here in here they say that the contractor or the contracting officer or the contractor may or will or shall. So you have to read these and understand where this one is, because this one here says it. This is a shall clause right here, which means it will apply in all situations. Next slide, please. Okay, we're still in subcontract settlements here. Okay, we got a couple slides on subcontractor settlements. Basically, the TCO will examine each subcontract settlement that is received, making sure that it's in good faith, it's reasonable amount, and it's allocable to the terminated portion of the contract. The TCO shall notify the contractor in writing of the approval or ratification. You want go back one slide, please. Oh, I'm sorry. Go forward one. Sorry, you missed 22. I'm sorry. Okay, my bust. I got the wrong slide here. We're on 23 now. Okay. Go back to 22, please. Yeah, I just want to finish up this on 22. The TCO shall notify the contractor in event of of termination, that in no event will the government pay the prime contractor any amount for loss of anticipatory profits or consequential damages as resulting of the subcontract. A very important point there. Basically, when you have a termination for convenience, everything stops at that point of time if it's a full termination. If it's a partial termination, you continue to work under the direction of the government that what can be done. But you cannot claim any anticipatory profits or consequential damages as a result of the termination. Okay, now 23, please. Okay. Again, the settlement procedure, the TCO, once the TCO makes a determination that the subcontract proposal is reasonable, good faith, and it's applicable to the terminated portion of the contract, the TCO will notify the contractor in writing of either approval or ratification of it, and if it's not approved, why it's not approved. So this is correspondence coming to the contractor from the TCO. Next slide, please. Okay. Now, this is an interesting section. A lot of this I'm not going to go into because it goes into a lot of details of in the weeds to me. For some, you have to be working on one of these to understand some of these procedures in here. But the TCO can request a prime contractor to conclude the settlement in whole or part without approval or ratification when the amount of the settlement is less than $100,000. So it's a dollar limitation there to where it's an expedited process to get money into the primes and subcontractors when the work is terminated. So next slide, please. This is an interesting one. Section 2 authority is granted to the prime contractor under a paragraph in this section by any by this section that by any TCO shall apply the executive agency's prime contracts that are terminated or modified by change order. TCO shall accept as part of the prime contractor settlement proposal settlement terminations of the lower tier subcontractors concluded by the prime contractor immediately, or lower tier subs who have been granted authority as a prime contractor to the settlement contract. And again, provisions of this section 1, 2, and 3 shall not apply to contracts under the administration of any contracting officer if the contracting officer so notifies the prime contracting concern. It has to be in writing, and paragraph A3 of this section is involved, and specifically any subcontractors affected. Next slide, please. Okay. The takeaway on this part of the subcontract is that this section shall apply to disposal of completed in items. So items that have come off the production line that have not been shipped, that are ready to be shipped, will fall under this section for the TCO. And part of the DCMA is the Cognizant Plants Clearance Officer, which is the firm that does settlements on if there's any government property in that plant that has to be taken back to the government or shipped back to the government. Okay. Next slide, please. How about give me thumbs up or something in the chat? How we doing? How you understanding this? Is it Greek or is it mush? Amanda will tell me what's going on there. Okay. We're finishing up this section of settlements without approval or ratification. What they do not want here is they do not want a separate settlement for a single subcontractor broken down into many smaller ones to bring it up under the authorized limit for settlement. They want everything to be consolidated whenever possible for a settlement for a subcontractor. Okay. Now they have other sections in here that are talked about that apply. So when you see these other sections like under item F, authority under 49.108-4, that's where you would go back to, and that's the section we're in right now. Shall not authorize the settlement of requisitions or orders placed with any unit within the contractor's corporate entity. Okay, so that's telling you that under this one, it depends how these orders are coming into the company. And then formats to be used for TCO's letters is talked about. Next slide, please. Okay. This section talks about judgment and arbitration awards. When a subcontractor obtains a final judgment against a prime contractor, the TCO shall, for the purposes of settling the prime, treat the amounts of the judgment as a cost of settlement with the contractor to the extent that the judgment is properly allocated to the terminated portion of the prime contract. Prime contractor has made reasonable efforts to include the subcontract termination clause described in the FAR, or exercise a similar excluding payment of anticipatory profits or consequential damages. Item 3, contractors made reasonable efforts to settle the settlement portion proportional of the subcontract. Okay. Okay, now 29. 29. We're still in the judgment arbitration section. Where do we go here? It's still different. Okay. Conditions of this paragraph, items 1 through 5, which are found on the previous slide, slide 28 of this section, are not met. The TCO may allow the contractor the part of the judgment considered fair and for settlement, and subcontract settlement proportional, given due regard to the policies and part of the settlement of proposals. What that is saying, that go back to slide 28, you have the 5, go back please. You have the 5 reasons here. That it can be included. Okay, so that's what they're saying related to this subsection on judgment and arbitration awards. Next slide, please. No, back to next slide. Yeah, 30, please. Okay, now another section of the FAR is assignment of rights under subcontracts. Termination for convenience clause 52-249, except the short form, obligate the prime contractor to assign to the government as directed by the TCO all rights, titles, and interest under the subcontract termination because of the termination of the prime contract. TCO shall not require the assignment unless it is in the government's interest. Okay. As a general rule, the prime contractor is obligated to settle and pay these proposals. However, when the TCO determines that it is in the government's interest, TCO shall, after notifying the contractor, settle the subcontractor's provisional using the procedure to settle of the prime contract. So there's example they use here, if it's a sole source and there's nobody else that can do it, then the settlement with subcontractor would not be incurred. They would just continue to work. Methods of settlement, slide 31. Okay, next slide, please. Okay. Settlement of cost reimbursement contracts and fixed price contracts may be affected by negotiating agreement determination by the TCO, or using a public voucher standard form 1034 public voucher for purchase of services other than personal, for cost reimbursement to the contractors. So there is a provision in here for settlement of this termination for convenience. Now we're going to roll into the next section after we have a section of questions and questions from you. Next slide. There you go.
Fantastic. And yeah, this is a perfect time. If you have any questions about termination for convenience and the FAR clauses that we have gone over so far, please enter them into the Q&A section. And if you can, Note the FAR clause that you are discussing, as well as the slide number, and we'll go ahead and give folks a few minutes. Imelda, I do see that your hand is up. If you have a question, I would love to let you talk if you are available and able to, but please do enter into the Q&A to let me know if that is something you would like to do. We'll give folks, and I see Imelda's hand went down, I'm assuming. Perfect. Thank you so much for confirming that, Imelda. As of right now, I'm not seeing any questions. We'll give it another moment or two. I know typing up the questions can take a minute as well. And this is a great time to remind everybody that this presentation is being recorded, and you will be provided with both the recording as well as the slide deck with all of these links active and clickable within 1 week of today's event. So you'll be able to go through the recording, kind of pause, take your time on some of the FAR clauses that you're really kind of maybe iffy on, or maybe want to go into more details. Explore all of those linked FAR clauses in the slide as well. So you'll be getting all of this as a resource for you and your business within 1 week of today's event. And I am still seeing no questions, so I do believe we can go on. And I will note we will have 2 other Q&A sections. So one will be after this next section, and then the final Q&A will be at the end of the presentation. So Joe, with that, we can go ahead and move on to termination for default.
Okay. Next slide, please. Termination for default is generally the exercise by the government contractual rights to completely or partially terminate a contract because of the contractor's actual or anticipated failure to perform its contractual obligations. Okay. Termination for default is the most severe of the two forms of termination. Again, in this section, it says if a contractor can establish that it was not their fault for termination, for causes beyond their control, without fault or negligence, the default clause prescribed in 49.503 and located under section FAR 52.249 provide that termination for default will be considered to have been terminated for convenience of the government and the rights of obligations of the parties govern accordingly. So if you as a contractor are you get a T for C, notice you have rights to be able to try to defend that T for C. I mean T for D, to make it a T for C. So it's not one-sided. Okay, next slide, please. Notwithstanding the provision in this clause, the contracting officer may, with written consent of the contractor, reinstate the terminated contract by amending the notice of termination after written determination is made that the supplier services are still required and reinstatement is advantageous to the government. So the government will come back and work with the contractor if they have something that's super critical and that they can work with them and give them some leadway to not have the termination for default. Okay. Next slide, please. The government has right and subject to the notice requirements of the clause to terminate contracts completely or partially for default or failure. If the contractor fails to make delivery of supplies or services performed within the time specified in the contract, perform any other provisions of the contract, make progress or fail endangers performance of the failure and endangers performance of the contract. So this is going back to the basic right of the clause. And this clause 52-249-8 is the termination clause for firm fixed price contracts. There are different clauses for the type of contract that is being terminated. There's different clauses for cost type contracts, cost plus fixed fee, cost plus award fee contracts. There is a different termination for a default clause in the Federal Acquisition Regulation. Okay. Next slide, please. I want you to look at this slide carefully. This is the effects of termination for default. You know, in Section A, the government may require the contractor to transfer title and deliver the government the completed supplies and manufacturing materials as directed by the contracting officer. The contracting officer shall not use the default clause as authority to acquire any completed supplies or manufacturing materials unless it is ascertained that the government does not already have title under some other provision of the contract. Contracting officers shall acquire manufacturing materials under default clause for furnishing to other contractors only after considering the difficulties the other contractor may have in using the materials. This goes to the manufacturing process primarily, where you're acquiring certain materials to make an item, and those certain materials sometimes can be long lead time items, or they are hard to get items, and you have them in your possession. So and if they're going to reuse them under another contract, the government would have the right to pay you the contract price for any completed supplies and the amount agreed upon by the contracting officer for any manufacturing materials that's acquired by the government under the default clause. Next slide, please. Now we have another list of lists. Okay. The government must be protected from overpayment and might result in a failure to provide the government's potential liability to laborers and material suppliers for liens rights outstanding against the completed supplies or materials after the government has paid the contractor for them. Before payment for supplies and materials, the contracting officer shall take one or more of the following measures. These 5 measures you can read here and look at what the measures are that they have to go through to make sure they've got everything properly covered before they can make a payment. Item 5, take other appropriate considerations and circumstances and the degree of the contractor's solvency. At least the government is saying they're not going at it and saying, we're going to get you. They're at least willing to work with you by that statement. Okay, next, move on to the next slide, please. Now, this is still under the fixed price termination contracts. When default termination is being considered, the government shall decide what type of termination action, default, convenience, or no cost cancellation, after review by the contracting and technical personnel and counsel to ensure the proper proposed action. Administrative contracting officers shall not issue a show cause notice or cure notice without the prior approval from the contracting officer, and it should be obtained in the most expeditious means. Now, next slide, we're going to talk about the cure notice. Cure notice is given to a contractor to tell them that you're giving the notice, you have time to go back to the government and say why you should not be terminated and how you're going to correct the problem. Okay. Contracting officer shall give the contractor written notice specifically for the failure to provide and provide 10 days or a longer period if necessary in which the cure notice in which to respond to the cure notice. When appropriate, notice may be made a part of the notice described in paragraph E1 of this section. Upon expiration of the 10-day or longer period, the contracting officer may issue a notice of termination for default unless it is determined that the failure to perform has been cured. Okay. Okay, next slide, please. This cure notice shall call to the contractor's attentions to the contractor liabilities if the contract is terminated for default, and request the contractor to show cause why it should not be terminated. The notice may further state that failure for the contractor to present an explanation may be taken as an administrative as not a valid explanation exists when the appropriate notice may involve the contractor to discuss the matter at a conference. Okay. That's a show cause notice. Item 4, next slide, please. We're on a different item here. Okay. If the contractor is a small business, the contracting officer shall provide a copy of the cure notice or show cause notice to the contracting officer's small business specialist and to the SBA area office nearest the contractor. So these individuals will come in to work with the contractor to help the contractor prevent the finalization of a termination for default. Next slide, please. Contracting officer shall consider the following factors in determining whether to terminate for default. And we've got seven items here. And number 3 is a critical item, the availability of supplies or service from another source. Item 4, the urgency of need for the supplies or service and the period of time required to obtain them from another source, as compared with the delivery time that could be attained from the delinquent contractor. And item 6, the effects of termination for default. Okay, and item 7, other pertinent facts and circumstances. So again, the government is wanting to work with the contractor and try to come to an agreeable solution, not to just say we're going to take it away from you. Now, the procedures for default. Next slide, please. Okay, we have another laundry list here of things that can happen. I'll leave this up for a few seconds and let you look at it, or minutes if you want it. For the contracting officer to determine if the default is proper, the contracting officer shall issue a notice stating all these pieces of information here, items 1 through 7 on this page. And you note my note at the top, this clause goes on from page 39, from slide 39 to slide 42. It's one clause. Okay, next slide, please. 48. More information for the procedures. Next slide. Okay, we've moved into the next section here. Other procedures other than termination. Following course of actions are allowed by the contracting officer if circumstances permit. Permit the contractor to continue performance contract under a revised delivery schedule. Permit the contractor to continue performance of the contract by means of a subcontractor or other business arrangement, provided the rights of the government are adequately preserved. Or requirement for the supplies and services for the contract no longer exists. The contractor is not liable to government for any damages. Then execute a no-cost termination settlement for that contractor. So the contracting officer has the ability to look at these other options. Contracting officers don't like to issue termination for defaults because the relationship that's been formed between the contractor and the contracting officer is a joint relationship to get a specific product or service delivered. When the contracting officer has to issue a termination for default notice, somewhere along the line, either the contractor or the government have failed in their ability to do that. And it could, it can have lasting effects on that company. It could put that company out of business. Termination for defaults and other terminations, or mostly termination for defaults, they're posted in a separate document that the contracting officers have access to that list you as being terminated for default. That termination can be either a lifelong termination or a period termination, which means you're not eligible for contracts during that period of time. So contractors need to be aware of the agreements in their contract, understand what's in the contract, and do everything they can to make sure they meet the delivery schedule. If you have any issues with the contract, you need to make sure the contracting officer is fully aware of those issues. So you don't get into a situation where you're in a termination for default arrangement. Next slide, please. Now, if you do get a termination for default, the government has the right to reacquire that service or the services you had under contract as soon as practical. Government shall repurchase at a reasonable price and as practical for consideration quality and delivery requirements. Contract, if they do the repurchase, they are billing you, Mr. Contractor, who's been terminated, for that cost. They cannot come in and charge you costs for new quantities being ordered other than what was in your contract. But they can come back and request reimbursement for the government's costs to re-advertise and reacquire that that material that was not delivered under your contract. Okay. And again, if they come back and want to acquire that cost and you don't pay it, then you're into a collection situation for the government, as prescribed in subpart 32-6 or 0.6. That's next slide. That's on the next slide. I'm getting ahead of myself here. But so there is if that repurchase is needed and you don't pay it, they're gonna demand the money under that repurchase agreement. And if you don't pay it, then the government's going to come after you for collection. And that's going to further hurt you in that publication of your name in the list of debarred contractors. So you want to stay away from termination for convenience default. You want a termination for convenience. The final slide. And then we go into questions. Again, contracting officer terminated contract for default following course of action instead of termination for default. The contracting officer promptly assessed and demands any liquidated damages to which the government is entitled under the contract. So you have a liquidated damages issue here. And if you have any other issues of other damages provided to the government, there may be a legal proceedings against the contractor to recover those costs. So that is the repurchase requirement. Repurchase requirement only applies to termination for default. It does not apply to termination for convenience. Termination for convenience means the requirement for the government has gone away, and termination for default means a vendor did not perform properly. So next slide, please, Amanda. Questions?
And here we'll go into questions. Please enter any questions you have into the Q&A section, or if you would like to ask Joe directly, please feel free to raise your hand and I will click the buttons on my back end to allow you to speak with us. And we'll go ahead and give everyone a minute. I do not see any questions in the Q&A as of right now, but please, if you do have any questions about the content, or even about how to connect with our services or maybe other resources you may be looking for your business, please do let us know. I'm happy to drop links wherever I can. And of course, we're happy to answer any questions about FAR Part 49 and terminations for default.
While you're thinking of your question, I just want to put out a piece of information for you regarding Part 49 of the FAR. It's a very comprehensive section. It's 75 pages long in that one section in the Federal Acquisition Regulation. And it covers every type of termination you could have based on the contract type. We only talk firm fixed price ones, because that's the most common contract vehicle we have in the federal government. But it goes everywhere you can think of. It even goes down to GSA orders, General Service Administration orders issued under GSA contracts. It's a massive link of ideas of how of rules and procedures to follow. So it's very complex. I know this was probably confusing to a lot of people. Sometimes it was confusing to me.
Definitely confusing to me. But it does look like we have a couple folks in chat. I see some thumbs up. Imelda thinks it's very straightforward. Honestly, for me, I think the amount of text can be kind of intimidating, but once you're reading through it, it can be pretty straightforward. It's just the jargon and the way it's written that can be a little bit complicated.
Yeah.
Fantastic. Well, with no questions at this point in time, let's go ahead and move on to the final two sections of our presentation today.
Next slide, please. Okay. What does the contractor have to do when they receive a notice of termination? Contractor shall comply with the notice of termination clause of the contract, except for otherwise directed by the TCO. Notice and clause applications for convenience terminations generally require that the contractor to stop work immediately on the terminated portion of the contract and stop placing subcontract orders thereunder. Terminate all subcontracts immediately. Immediately advise the TCO of any special circumstances that precluding the stoppage of work. Performance and continued portion of the contract and submitting promptly any requested request for equitable adjustment or price for the completed portion supported by evidence or any increase of cost if the termination is partial. Next slide, please. Take necessary action to protect and preserve property in the contractor's possession, which the government has or may acquire as an interest and directed by the TCO, delivered to the properly to the government. Promptly notify the TCO in writing of any legal proceeding growing out of any subcontract or any other commitment related to the termination portion of the contract. Settle outstanding liabilities and provide and proposals arising out of termination of subcontracts, including any approvals and ratifications required by the TCO. Promptly submit the contractor's own settlement proposal, supported by appropriate schedules, and properly disposed of terminated inventory as directed as authorized by the TCO. Next slide, please. Again, a subcontractor has no contractual rights against the government upon the termination of a prime contract. It's a legal term called privity of contract. The contract is only between the prime and the government, not the subs. The subcontractors have rights against the prime contractor or intermediate subcontractor to whom they are contracted. Upon termination of a prime contract, the prime contractor and each subcontractor are responsible for prompt settlements of their settlement proposals to their immediate subcontractors. So if you're third tier down subcontractor, you go up, you send your information up to the second tier would then forward it up to the first tier. And then first tier would forward it to the prime. So it can just up the line to get your settlement taken care of. Next slide, please. Now, what do you need to be aware of? Protecting your business. First of all, you've got to be aware of FAR Part 49 and the clauses in part included in Part 52. All clauses related to federal government contracts are in Part 52 of the FAR. Okay. Document everything in writing, especially any phone calls you get. Save all written correspondence. This is going to be your basis for help you to get that T for C handled properly and completely. Contact your legal advisor as soon as you receive any notice to stop work on a stop work order. This is for either T for C or T for D, and this will ensure your legal rights are preserved. There are different legal rights, and I cannot speak to those as what they are, but you have to preserve those or they're gone because of the type of termination you have. Issue timely written notifications to your employees, suppliers, and subcontractors. Don't keep it a secret that your contract is terminated. Let everybody know about it so they can take action also. Be responsive to the contracting officer or the technical contracting officer, or termination contracting officer, I'm sorry. Review your file so you know where you are in your contract performance. And know where you are in reference to any outstanding payments that are due. Next slide, please. Now, termination clauses. What I've concluded here are the two basic termination clauses, not full text, because the full text would be 5 or 6 slides apiece. So I'm not going to have you look through them, but these are partial displays. These are the first sections of each of the clause. FAR 52-249-2 is firm fixed price termination for convenience. Okay, and it's just the first section of it. There's other things behind it that you need to be aware of. Next slide, please. Now, 52-249.8 or -8 is the firm fixed price supply and services for default. Okay, this is the first two sections of it, and it has about three more slides worth of information. These references, they're all in the reference I gave you for the acquisition.gov at the beginning of the presentation, and that Amanda put into the chat, I believe, also. Now, I want you to fasten your seatbelts because the next slide is going to be kind of an eye opener to you. Next slide, please. GAO data for fiscal year 2024, 1 October 23 to 30 September 24, said nearly 40,000 contracts were terminated by the government. 40,000. Figures for the current year, 1 October 24 to 30 September 25 are not available, but contracting initiatives of the current administration has spurred additional terminations to take place. I personally have 3 clients right now who are clients of the Norcal APEX who have received stop work orders. They haven't received termination yet. They just received a stop work order. So things are happening across the board. So just know that this is a critical area right now to be aware of. Awareness is going to be, at least basic awareness is going to help you versus having no idea what to do when you get a stop work order. Now, questions?
All right, and this will be the final Q&A section of our event today. We are just about to wrap up. So please do put any questions you may have, whether that's about the content, about FAR, or if you're looking to connect with Apex Accelerator services, please do let me know. I'm happy to help you connect with your local center. So we'll go ahead and give it a minute, as I do not see any questions right here. It seems like everybody's kind of, now that they've gone through it, didn't have to see it in its 70-page entirety.
Either there's no question because you're numb or you're overwhelmed. Probably both.
And the best part is that's okay, because you will be
Yes.
receiving both the recording as well as the slide deck later on within a week. And so you'll be able to review all of this information at your own pace, and you'll be able to explore the FAR, dive more in depth into the topics that may be specifically related to your business. So you will be getting both the recording of this event and the slide deck with all links active and clickable within 1 week of today. And I do see a couple of questions,
Great.
definitely about that last slide.
Okay.
So Jamie is wondering, out of that 40,000, what industry was impacted most by those terminated contracts? Was there something like a clear industry that was hit harder?
I could not determine what industry was affected or how many were termination for convenience or how many were termination for default from the data I saw.
Yeah. And Imelda was asking a similar question, what the breakdown of the 40 cancellations was. Did the data have any information about like what contracts they were looking at canceling or what contracts were terminated? Was that just not present in the data?
I think one of the columns did have contract numbers on them, but I don't
Okay.
remember for sure.
And the website you pulled this off of, it is publicly accessible. They could go explore this on their own.
General Accountability Office is the office that handles all the protest.
Okay.
So if a contractor files a protest and pays their fee, the General Accountability Office is going to handle the protest unless the protest is handled at the agency level. But General
Okay.
Accountability Office does protest, and so that's probably a lot of that number could be a protest being awarded to somebody other than the contract holder, and that contract was terminated as part of the protest award.
Okay. So that is good context. And I did just drop that link to the website for everybody here in case you want to go in and maybe dig around and see if you can find more information and more detail about that. Please do feel free to do so. Again, this is a government website, all public information, all public data that you can explore on your own time. And as it looks like,
I knew I would get some questions on that number.
honestly, it popped into my head too. And I'm like, wait,
Yeah, yeah.
what contracts? Was there like a target? Who would be impacted most? It's kind of like we're looking to identify what industry is the least stable contract in a sense, which is really good business, but maybe not something the data can provide.
Yeah, yeah. It may be providable with more in-depth research.
Yeah.
Um,
And your
now,
procurement specialist can help with that. So if you are looking to get into that in-depth kind of data, definitely sign up for either Norcal APEX Accelerator or for one of our other sister centers across the nation to meet with a procurement specialist just like Joe Moore, who can help you go really in depth into that and really fine tune that almost market research that you would do.
the other thing I want to mention that some of these contracts that were canceled, they could be grants because grant is
Mm,
just a form of funding, but the vehicle that provides that funding is a contract.
yeah,
So it could some of these could be grants that were canceled in 2020 FY24. You know, a lot of stuff's happening right now in FY25, and we have no idea what that number is going to be.
absolutely.
But
And so,
so that could be it could be contracts, it could be services, it could be parts, it could be grants, it could be SBIRs that were terminated. It could
mm,
be anything because all those are different vehicles, but they're all putting funds. They're putting funds in contractors' hands, but they all a contract document that comes to the contractor, regardless of what the program is.
yeah.
So the definition could be contracts based across that whole spectrum.
That makes sense. That's really good nuance to it. Fantastic. Well, since we don't have any more questions, I will wrap us up for today. As we end the webinar, I do want to let you know a little bit about some of our other upcoming trainings, especially our federally focused ones. On August 5th, we'll be covering federal contracting certifications for your small business. And then on August 13th, we'll be going into an introduction to defense contracting, specifically how to contract with DoD. And then to round out our August events, we will be covering tools you will need to succeed during the uncertainty that we're seeing in the federal contracting space. And to begin our September lineup of events, we'll be covering how you can interpret, that's the word, interpret DoD solicitations with confidence. So if you are interested in joining us for one of our other federally focused events or one of our other many events covering state and local contracting as well, please do check out our event calendar online. And with that, I would like to thank everybody for joining us today. And thank you so much, Joe. The FAR is a lot to get through, but I know it provided so much valuable information for everyone here. So thank you so much for this presentation, Joe.
Thank you. Thanks everyone
And
for being here.
yes, absolutely. Thank you all so much for joining us this morning. As you exit the webinar, you will be redirected to our feedback survey. If you do have a brief moment, we would really appreciate your feedback on this event. If you really like the content and want to see more advanced topics such as this, please do let us know. And maybe this wasn't quite your speed. Maybe you want to see more about certifications or more about a different federal topic. This feedback survey is the place to let us know how we can tailor our trainings and our training offerings to better suit your business and your business's needs. So if you have a moment, we always appreciate your feedback. And with that, thank you once again for joining us. And I hope you all have a fantastic rest of your day.